Michigan. What'd you do at the Target store that makes you think that you're guilty?
I shoplifted items from Target while it was open to the public.
Okay. All right, you went into Target, is that correct?
Yeah.
You took some items that they had offered for sale,
Yes, Your Honor.
and then you tried to walk out of the store or did walk out of the store without paying for those items?
Yes, Your Honor.
And it's not value. And was the total amount of the items that you took that indicates that the defendant will be pleading guilty to the charge of retail fraud in the second degree, the 1-year offense, which is as charged, and that there is a sentence agreement to HIDA?
That's correct, Your Honor.
That's correct, Your Honor.
All right. Ma'am, can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record.
Martasia Davis.
Ma'am, you can put your hand down. It is this court's understanding you're going to plead guilty to the charge of retail fraud second degree. That's a misdemeanor,
Yes.
punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty?
Do you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
All right. You had signed or had somebody execute an advice of rights on your behalf, is that correct?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
No, Your Honor.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes.
And let me find my complaint. Like that. I think people. Hold on one moment. Where they put it? On the date of January 2nd, 2026, at the location of 2000 Waters Road, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do at the Target store that makes you think that you're guilty?
I shoplifted items from Target while it was open to the public.
Okay. All right, you went into Target, is that correct?
Yeah.
You took some items that they had offered for sale,
Yes, Your Honor.
and then you tried to walk out of the store or did walk out of the store without paying for those items?
Yes, Your Honor.
And it's not value. And was the total amount of the items that you took in excess of $200?
The total amount?
Yes.
Like, of how much we took? I would say,
Thank you. Your Honor, we would stipulate to the report it would be a total of $334.
$334. You have any objection to that stipulation, ma'am, or agreement that that's the amount that was taken?
I agree, Your Honor.
All right. Ma'am, I do have to advise you that if you commit misconduct as defined under the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Are parties aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
The defense is satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 22nd, 2026, 9 a.m. Bond in this matter will continue. Ma'am, I'll ask you to remain on the line.
The Secretary of State, based on that, I'm going to add count double parking. That's an admitted responsibility of the parking that be accepted in this original charge.
That is correct, sir. And my client informed me she could pay that today, Judge.
But I was going to set it really high.
Oh, okay. That was-
Do you admit responsibility to the fact that on May 5th, 2026, location of Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, Your Honor.
Or will accept that admission to count two. Count one is dismissed. Fines and cost of $180. I'll just do the standard.
Thank you, Judge.
And ma'am, you can pay that today.
Yes, Your Honor.
All right, thank you.
Thank you.
All right.
Judge Simpson, appreciate you.
Here.
Have a good.
No, I'm not saying goodbye to you. Ms. McDuffie, you have a wonderful. Court calls the case. People versus LaShawn Covington.
Honor, that's all I'm getting.
You're right, Mr. Mack. That was rude. You have a good day too.
Brandon with no counsel.
Your name?
Sean Covington.
All right, Mr. Covington, you are before the court on a complaint that alleges that on or about April 25th, 2026, location of Gulfside Road in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle while your license was not valid or an improper license. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes, sir.
Okay, first question I have for you. Do you wish to be represented by an attorney?
Yes, I would.
All right. This is a public defender's case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Covington. Your Honor, as it relates to any additional formal reading of the complaint, we will be standing mute as to the charges, and I'll be requesting a personal conference bond based upon my client's appearance here today in court.
Been in every way formal reading, standing mute. Court will enter a not guilty plea. Okay. Pretrial in this matter will be set for
July 1st.
July 1st, 2026, 9 a.m. Bond will be set at $5,000 personal recognizance bond, standard conditions, including no assault to behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. All right. Just, because looking toward potential resolution in this case, it's not that was in 20.
Your Honor, just to, I think, clarify what is going on. My client has paid the reinstatement fees for his license, from what I can see on his portal for the Secretary of State. It looks like he just needs to go do some final in-person steps. So
That's what I was going to say.
He'll be able to have this. He has an appointment for that next Tuesday, so I believe we should be able to get this resolved hopefully by that first date.
So I didn't know that anybody knew that. I was just going to indicate he's not suspended. His license is there's a different category of just being expired.
So
He has to do some things too.
I gotta go take
take the picture and do all that kind of stuff. Yes.
You gotta take a picture.
Yep. I gotta just go down there and I gotta take the picture.
See. Okay. Well, good luck to you on that. No. All right. All right. Try to get all that done so we can get this resolved when you come back. All right, young man. All right.
Thank
Take care.
Thank
See
you.
you. No problem. See you.
Court calls the case People versus Basola Lambo.
Conrad Silver, yeah, Smith Township.
Ron Brown appearing on behalf of Basola Lambo.
Hey, here. Oh. Basola Lambo.
Yes, give me one moment. I'm trying to just get to my phone so I can get in the camera.
That was like talking to the clown at the. Excuse me.
Sorry, I'm trying to get to my phone so I can turn my camera on.
Okay, I understand. Now,
Sorry about that. How you doing, Your Honor?
I'm doing okay. Your name?
Basola Lambo.
All right. What are we doing?
Your Honor, I'm requesting final settlement and jury selection.
Jury final settlement conference. August 7th, 2026. 9 a.m. Jury selection, if necessary, August 10th, 2026 at 8:30. Both of those proceedings are in person.
Okay, thank you.
Thank you.
Thank you. Bond continue.
Have a great day.
You do the same. Courthouse case, People versus Justin Moser.
Conrad Silver, I mean, Smith Township.
Ron Brown appearing on behalf of Moser here.
Should I tie my shoes, sir?
That's not really the problem. You tell him?
Tuck your shirt in.
No, it's not the problem.
Gum.
He forgot the bottom half of his pants.
Oh, yeah, no shorts.
Oh, okay. Sorry. I'm
All right, go ahead.
Your Honor, we're requesting an adjournment. We're trying to work out a global.
He has. Is he before me on that?
I
Or
think he has a PCC on the 26th. Is that correct?
I believe it's the 25th.
25th. So the 20,
okay.
20,
July 15th. I'll adjourn these to July 15th.
Your Honor, Matt Poach with the prosecutor, very brief.
Yes.
Thank you. We'll see you on the 15th.
Court calls case. Look here. People versus Stephen Lee Osborne Jr.
Conrad Silver, on behalf of Smith Township.
Ron Brown appearing on behalf of Mr. Osborne.
Oh, there he is. Sir, unmute, state your name, please.
Your Honor, Stephen Osborne.
Thank you.
Your Honor, I'm requesting an adjournment. I'm trying to get additional discovery in this case.
Adjourn this matter July 15th, 2026, 9 a.m.
Thank you.
Court calls the case People versus Manik Razdan.
Conrad Silver, on behalf of Smith Township.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Razdan, who should be appearing via Zoom.
Yes, Manik Razdan.
Thank you.
At this time, Your Honor, offer has been extended by Mr. Sewer. However, we need to look into some potential collateral consequences of my client accepting the offer. So I'll be requesting an adjournment.
July 15th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Andre Rison.
Conrad Silver, on behalf of Smith Township.
Ron Brown appearing on behalf of Mr. Rison. Can you unmute Mr. Rison and introduce yourself to the judge?
Sorry about that. Andre Rising.
All right, I have before me a plea form that indicates that he's going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. the 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. I do not have his signature on this, however, but
He's given me permission to sign in his absence.
all right. Is that the court's understand? Is that the correct understanding of the agreement?
That's correct.
Yes, Your Honor.
Mr. Risen, can you raise your right hand, please, sir?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please, sir.
Andre Rising.
All right, you can put your hand down. Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail or $100 fine plus court cost. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, sir.
You understand that you're giving up the rights contained in paragraph 5 as well as all the rights contained on the form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Pardon?
Are you on probation or parole?
No, Your
I'll
Honor.
ask it a different way. Are you on probation?
Yes, Your Honor.
You are?
Your Honor. Hello?
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 Can you hear me?
Now I can.
Okay. Are you on probation?
No, Your Honor.
Are you on parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will.
Yes, Your Honor.
On April 8th, 2026, South State Street in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, Your Honor.
Did you allow someone who was otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
Thank you so much, Your Honor.
All right. Fines and costs of $250. I'll suspend 90 days in jail. When can you get that paid, sir?
10 days.
All right. Why don't I do this? So you can get it paid before the end of the month.
Yes, Your Honor.
All right. Pay it by June 30th.
Sure bet.
All right. Thank you, sir.
Thank you so much. Thank you, Ron.
Welcome, Mr. Rising.
Court calls the case. People versus Selma Sabic.
So on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Selma Sabic.
Sabic? I'm sorry?
You're free, Mr. Rising.
Oh, dear.
You were prompted, sir.
Selma? Now let me pass that she's there. Court calls the case of People versus Cleotha Williams.
So on behalf of Township.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Williams, who's appearing via Zoom.
Can you unmute and state your name, please, sir?
Looking on how to unmute. So he's getting assistance.
Right?
He's getting.
Yeah.
Okay, man, I'm here. I'm here. Sorry.
Okay,
Sorry, Your
I
Honor.
got you. No,
I'm sorry,
we were
sir.
watching you walk all around. We got you.
I'm sorry,
All
sir.
right.
I'm sorry.
No, you're good. Don't worry.
Okay.
Don't worry about it. All right.
Okay. Okay.
You only have
Yes, sir. Yes, sir.
All right. State your name for me.
Cleophas Williams, sir.
Right. I have before me a plea form. He's going to plead to an added count 2 of allowing an unauthorized driver to operate a motor vehicle. The 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
Again, state your name.
Cleophas Williams, Senior, sir.
All right, you can put your hand down. Sir, it says court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle.
Yes, sir.
That's a misdemeanor punishable by up to 90 days. That's okay. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. You have any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up all of the rights that are contained on that form, inclusive of the rights in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily and of your own free will?
Yes, sir. Yep. Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
All right. On September 8th, 2018, location of Bemis Road, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes, sir.
And at that time, did you allow someone who was otherwise ineligible and maybe inclusive of yourself to operate that motor vehicle?
Yes, sir.
Now, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you or your attorney want to say before I impose sentence?
I say I apologize.
Okay, good. Fines and costs of $250. I'll suspend 90 days in jail. When do you think you can get that paid?
Hey, sir, can you give me 30 days? I probably can make a payment next week, but can you give me 30 days to pay the whole $250, please?
He said, please.
He did say please, Your Honor.
Well, you know what? Most of your clients don't tell me, please. I don't know what it is. This client seems like a nice guy. Here's what I'm going to do. How about I give you a little bit more time than that as you're trying to work it out? I'm going to get it paid by August 31st.
I appreciate you, sir.
All right? You're all set.
Okay, thank you, sir.
Take care of
Have a good day. Appreciate you.
Thank you, Your Honor.
Court calls the case versus Cole Wallach.
Honor, it's still running.
Or Wallach.
Ron Brown appearing on behalf of Cole Wallach.
Oh, there he is. Sir, state your name.
Cole Wallach.
All right. Plea form indicates the defendant's going to be pleading as charged to retail fraud under the Pittsfield Township Ordinance, a 90-day offense. Upon his successful plea to that charge, well, then there's also a sentence agreement. Prosecutor agrees to sentencing under HIDA.
That's correct.
Yes, Your Honor.
All right. Sir, please raise your right hand. Please. Sir, are you raising your right hand?
Yes,
Okay.
sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth to help you God?
Yes, sir.
State your name again for me.
Cole Wallach.
All right. You can put your hand down. Sir, it's this court's understanding that you're going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
I plead guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Any question regarding any of those rights?
No, sir.
You understand that you're giving up all of those rights, inclusive of the rights contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threatened you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
March 5th, 2026. Location of 7000 East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan. What did you do at the Walmart that makes you think that you're guilty?
I walked out of the store with items with the intent to steal them.
Okay. So you were in the store and you somehow and or another concealed those items or tried to walk out with items?
Yes, sir.
And these items were items that were offered for sale by Walmart?
Yes, sir.
The store was open to the public at the time, is that correct?
Yep.
And is it also correct you didn't have anybody's permission to take that property?
That's true.
All right. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. Do you understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
July 22nd.
July 22nd, 2026, 9 a.m. Bond will continue. Hold on a minute, sir. And what we're going to do is we're going to put you into a breakout room with my probation intake so that way we can get the sentencing part started, okay?
Okay.
All right, thank you. You got it?
Yep.
Court recalls the case of People versus Selma Sabic.
Conrad Silver on behalf of the Township.
Ron Brown appearing on behalf of Mr. Sabic.
Can you please state your name?
Yes, Selma Sabic.
Sabic. Got it. I knew I was going to blow it either way I tried to pronounce it. So I just said I'd pick one. All right.
That's so fair.
Okay. I have a plea form. It indicates that the defendant is going to be pleading guilty to the charge of allowing an unauthorized individual to operate a motor vehicle. That 90-day misdemeanor, upon successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the.
That's correct, Your Honor.
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
State your name again for the record.
My name is Selma Sabic.
All right. You can put your hand down.
Okay.
Right. It's court's understanding that you're going to be pleading guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail, a $100 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Absolutely not. I'm good. Thank you.
Okay. You understand that you're giving up all of the rights contained on that form, including the rights under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not that I'm aware of.
Okay. You're not under
Sorry,
the
I'm cold.
jurisdiction of any, well, hold on. You're not under the jurisdiction of any other court or required to report to any other court, are you?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
I'm sorry, response to that?
Oh, I said no.
All right. Has anybody threatened you or coerced you in any way?
No, nobody has.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
On the date of April 18, 2026, Carpenter Road in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, I was in control of a motor vehicle.
Okay. Did you allow somebody who was otherwise ineligible, inclusive of yourself, to operate that motor vehicle?
It was myself that was the one that was driving. So
Right. And you were
yes,
ineligible at the time. Is that correct?
Yes. Yes, it
Counsel,
is.
have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Is there anything you want to tell me before I impose sentence?
No, nothing else.
All right. Fines and costs of $250. I'll suspend 90 days in jail. When can you get the $250 paid?
I can probably get it done today, pretty sure.
Okay. Try to get it done today. I'll give you to the end of the month to the 30th, okay?
Okay, good. Thank you.
You're welcome. All right. You take care of yourself.
Yes, thank you. You too.
Court calls the case. People versus Gabriel Steele.
Conrad Sullivan on behalf of Pittsfield Township. This is
Okay. Is it here? Steele. Well, they said it for show cause today.
yes.
Let's just do it this way. Bench warrant will issue. Bond will be set in the amount of $3,000, 10%. That warrant will issue immediately. Court does call the case. This versus Malcolm Stevens.
Conrad Sullivan on behalf of Pittsfield Township.
Show cause, no counsel, and not checked in.
Malcolm Stevens. No response. Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $3,500, 10%. Warrant will issue immediately. What? Mount?
My files.
You're out of files? I'm out of files. All right, 14A stands adjourned. Everybody can remain seated.
Yes, sir.
Your name, sir?
Richard Larson Asplin.
So you are before the court on a misdemeanor complaint that alleges that on or about the date of May 16, 2026 at the location of 2153 Arbor Circle West, apartment 207, that you did commit an assault or assault and battery upon a Karen Joan Asplund. Do you understand the nature of that charge, sir?
I understand.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand those penalties?
I understand.
All right. First question I have for you, sir, is do you want to be represented by counsel?
Yes.
All right, this is a public defender case.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Richard Asplund. At this time, Your Honor, as it relates to the formal charges, we will waive any additional reading and be standing mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. You is adjourned.
Yes, Your Honor.
Pretrial in this matter will be adjourned to July 1st, 2026, 9 a.m. As to bond.
As to bond, Your Honor, I'll be requesting a personal reconnaissance bond in this matter.
Your Honor, I'll be requesting a no contact order with the named victim as well as a sober link device. The report does indicate that alcohol was involved during this assault. My understanding that the named victim is the sister of the defendant. They were living together, but I think they were in the process of moving out. So I don't know if a no go to is necessary at this time because of the moving of the address. I have no objection to the defendants.
All right. I'll set the defendant's bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons or ammunition. You understand that, sir?
Yes.
I'll also order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
Do you need to have contact with this individual?
Absolutely not.
Okay. So I'm going to order no contact with Karen Joan Asplund. Okay. Prosecutors indicated that this might have been a move out situation at some point. Are you still residing? The address we have for you is the Arbor Circle address. Is that still your address, sir?
No.
No. All right. You'll need to make sure to update your address with the clerk's office up front. Do you know if this individual is residing at that address? Do you know?
Do I know?
Yeah.
But she is not.
I'm sorry. Go say that again for me.
No, she is not.
She's not. Okay, then I'm not going to issue a no-go to. All right. I will order the defendant to report to community corrections for placement on a sober link testing device. All right. Anything further?
No, Your Honor.
Thank you. Court calls case, People versus Ezra Yoder.
Morning, Your Honor. Raymond Cook for the people.
Arabian pre-trial and counsel. Not checked in.
Ezra Yoder. Okay. The previous bench warrant in this case, we reissued the notice because there was a problem with the previous notice. Defendant not appearing now, bench warrant will issue $5,000, 10% privilege. That warrant will issue immediately. Court calls case, People versus Deshauna Andrews.
Henry Silver on behalf of the township.
Ron Brown appearing on behalf of Ms. Andrews.
Not checked in.
Deshauna Andrews. No response. Bench warrant will issue for defendant's failure to appear. Bond $5,000, 10%. Warrant will issue immediately. Court calls the case of the People versus Latanya Barney.
Henry Silver on behalf of Kingsfield Township.
Ron Brown appearing on behalf of Ms. Barney.
There she is. Hello, what's your name?
Hello, Latanya Barney.
Thank you. What are we doing?
I'm requesting an adjournment so that she can work on her SOS appeal process.
I'll adjourn the matter July 15th, 2026, 9 a.m. Court calls case People versus Christina Bowling.
Ron Brown appearing on behalf of Christina Bowling. Right here.
Your name, ma'am?
Christina Bowling.
Thank you.
Your Honor, I'm requesting an adjournment. She needs to take the road test. As we
does?
Yes.
Pass the written test?
Yes, I already passed the written test. I've already had my license, but I got to retake a road test. So.
Are you going to pass it?
Of course.
Think so?
Of course.
So you already know how to drive?
Oh, yeah.
You know, if you come back and you didn't pass the road test, you know what? They're going to laugh. I'm not. Do you know how to parallel park?
Of course.
Something you'll never have to use, but
crazy.
Okay. How long is it going to take you to take the road test?
I just got to set an appointment. So, I would say we talked about a month, maybe like, to get it all set up and done. Give or take.
You think she's going to pass? Yeah. No, I've got confidence in you too.
Thanks.
All right. July 15th, 2026, 9 a.m. And I do wish you all the best on that test. All right.
Thank you.
Let us know where it's happening in case you go wild.
Hey, Judge, sorry to interrupt. Was I caught yet?
Court calls the case, People versus Samuel Carson.
Ron Brown appearing on behalf of Mr. Carson.
Samuel Carson. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Please. Second, I have good initials. $5,000, 10%. That warrant will issue immediately. Court does call the case. People versus Timothy Case.
Conrad Solar on behalf of Township.
Ron Brown appearing on behalf of Mr. Case, Your Honor.
Your name?
Timothy Case.
I have a plea for him that he's going to plead to an added count 2 of allowing an eligible driver to operate a motor vehicle. The 90-day misdemeanor. On a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding.
That's correct.
Correct, Your Honor.
May I have sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
State your name for the record.
Timothy Case.
Sir, it is the court's understanding. We're going to be pleading guilty to the charge of allowing an eligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court cost. Do you understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
And you understand by pleading guilty that you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
No, I am.
Has anybody promised you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Sir.
Of your own free will?
Yes.
And because you believe you're guilty?
Yes.
All right, let's see. On April 30th, 2026, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, do you have custody or control of a motor vehicle?
Yes, I did.
To allow someone who was otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
I let myself drive.
You were at that time ineligible?
Yes.
So the answer to my question is yes.
Yeah.
All right.
Sorry.
No, it's okay. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you or your attorney want to say before I impose sentence?
No.
Fines and costs of $250 and I'll suspend 90 days in jail. When can you get that paid?
I can pay it today.
Hey. Thank you. Pay that today out at the counter and you're all set, sir.
Thank you, sir.
You're welcome.
Sit. Yes, sir.
Whatever. Okay. Court calls the case. People versus Caitlin Davidson.
Conrad Silver on behalf of Pittsfield Township.
Ron Brown appearing on behalf of my client, Your Honor.
Caitlin Davidson.
Yes. Caitlin Davidson, sorry, I'm at work.
All right. She's got two, these two are set and then she's got an arraignment.
It's not an arraignment, it is a schloss for prelim.
Okay. It's a prelim. It was. Okay, there's a problem. I've got these two cases that she has here, but I also have a failure to appear or on a prelim. And you know how I feel about that.
Could I start?
I don't know if you're gonna make it worse.
She needs to be here.
Judge says you need to be here so that you can get arraigned on the warrant for your non-appearance at a preliminary examination.
I'm aware. My lawyer, I contacted my lawyer on it and we tried to do it last week. But when I went up to the courthouse, he told me that I would have to do it next Wednesday because they only do it on Wednesdays because he's stuck in the courthouse. I've been trying to do it. I did several warrant recalls.
I didn't tell you that.
No, I was talking my court on the other case he's talking about that I was failed to appear on.
Did we conflict off that case, Your Honor? The felony?
She's okay. It's Mr. Burgess that represents her on that, but
so until you address this warrant, obviously it still exists, ma'am.
I understand. I was coming to address it on Wednesday.
Do you have Mr. Burgess' number?
I do. I just was in contact with him. And he rescheduled it for this Wednesday. Well, not this Wednesday, but next Wednesday. Not like today. Because I told him I had court with you. And he told me to make it, we're going to do it next Wednesday. The walk-in warrant. Because he'll be with me, so they won't take me to jail.
We hope you don't come in contact with police before that.
I haven't, I won't. I actually got put on probation in Wayne County, so I can't be in contact with any police.
what am I doing on the other cases?
Adjourn or set final settlement if we run out of time.
Yeah.
Price.
Jury final settlement conference, August 7th, 2026, 9 a.m. Jury selection, August 10th, 2026 at 8:30. Both of those proceedings are in person.
Okay.
All right.
Thank you.
And her boss that skills.
Yeah, sure.
She's gonna have to get herself in. Gonna do anything with it. She's not here.
I'm
Good
sorry.
luck, Ms.
I'm not gonna do anything with it. You gotta go get yourself arraigned on the bench warrant because it's failure to appear at a PE and I require people in person.
All righty. Yes, sir.
Thank you.
Thank you.
Oh, my God. Court calls case, People versus Diamond Ford.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Ford.
Ms. Ford, state your name, please.
Diamond Ford.
Thank you.
I'll be requesting a adjournment. Now I was unable to make contact with my clients this week.
Doing it July 1st, 2026, 9 a.m. Oh, no.
What produced?
You know what? I was having a good day. And then, no, you messed the whole thing up. Yeah. Court calls the case, People versus Zane Franklin.
All right, so on behalf of this township,
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Franklin.
Shanae. I'm sorry. Ma'am, state your name.
Johnny Franklin.
Yeah, I knew it. But Mr. Bukovich was telling me it was Jane.
Zane, yeah,
Yeah.
it's pronounced like that.
He did that. I didn't.
It is definitely my fault, Your Honor.
All right.
I would request an adjournment. I was trying to reach out to you, Ms. Franklin, but I read the numbers the public defender's office have are old. There's one I called and the person keeps hanging up on me, and two
Yeah.
that definitely not belong to you. So you may need to reach out to my office to get us an updated phone number.
Okay, I will.
All right. Just make sure you got the number.
I don't. Could you can someone give it to me real quick?
Yes.
Yes.
So,
all right. You ready?
Yes, I'm ready.
All right. It's 222
Uh-huh.
6970.
Okay, yes.
Call them, tell them who you are, give them a good phone number and make sure they have a good email address for you.
Okay, thank you so much.
You're welcome.
All right, bye-bye.
Thank you, Ms. Franklin.
I'll adjourn this to
Thank you.
first.
Thank you, Your Honor.
All right. Then recall the case of the People versus Craig Rosecrans.
Morning again, Your Honor. Raymond Folks of People.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Rosencrantz, who should be appearing via Zoom.
Sir,
Craig
state your
Rosecrans.
name. All
Craig
right, good.
Rosecrans.
Now we can hear you. Okay.
Okay.
What are we doing?
I'll be asking for an adjournment to allow us to finalize the plea offer. We're just looking into some collateral consequences of him accepting this plea agreement. But I believe we should have this case resolved soon.
July 1st, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
Continue. That was,
11, Your Honor.
and now my clock is 12.
Yes, but you would serve with Mr. Gann.
Okay, I got to roll.
Like,
Huh?
we saw you.
No, I'll let you get it, but I'll take a break. I'll come back out because you said I'd have to start with Mr. Mack.
There's a good chance.
Okay, then I gotta go. Court of State is recess.
all rise.
Honorable Jason.
Maybe seated. Back on the record in the case of the People versus Fault. Jackie, you may continue with your.
Thank you, Your Honor. I want to clarify that my argument is not that Stevens just to presence at the side of the highway or the roadway was the superseding intervening cause. Ms. Grady testified that the decedent ran towards her vehicle in the minutes leading up to the accident, such that it caused her to lock the doors and think that he could be a danger to himself or others. So this is different from any situation in which any medical or police or any other person is just merely on the shoulder of the highway or standing on the shoulder of the highway. In those cases, the actions of those individuals likely, we wouldn't have testimony that someone was running towards incoming vehicles. And I just also want to highlight that she and the officer specifically referenced safety protocols and procedures in place to entail safety when there is an ambulance on the side of the highway. So we heard specifically testimony which involves preventing cars from traveling in the lanes nearby, restricting travel on the highway for this reason. So that would be my argument, Your Honor.
Anything additional?
Briefly, Your Honor, touching on 2 points defense counsel made. Defense counsel rested in part her argument that the defendant or the decedent was acting erratically. I believe the language was charging at the ambulance. My recollection of the testimony from Miss Grady was that the defendant was off the lane of travel on the shoulder at the time that this crash occurred. So to any extent that he was acting erratically in the place where the defendant shouldn't have been driving regardless of what he was doing, because the defendant should be maintaining the lane of travel, not driving into the shoulder. Defense counsel also, I believe, made an argument before we took the recess that there's no evidence other than the defendant's statement to Sergeant Bowden about how fast the vehicle was going. And while certainly there was no mathematical calculation put before the court, I believe the testimony was that the decedent was found, I believe it was about 10 yards off the road, which then had several more feet from the fog line to the end of the pavement. And that itself was, I believe, the Miss Grady testified about 150 yards down the road. To move that far from the early indicates that it does not give an exact number, but it corroborates the defendant's own admission to Sergeant Bowden that he was going 90 miles an hour approximately. For those reasons, for the reasons I originally stated in my motion for bind over, I would again move this court bind the defendant over on the information.
Sorry. Okay. All right. Let me just say at the beginning that I think that maybe the decedent's family back there, and I've been watching the defendant ever since sitting on the bench. The cases that the defense of what might be negligent homicide, but they are always difficult because a lot of times in cases you have good people, you have bad people. But in these cases, you can have good people all around, and a bad thing has happened, and it's not. It just is what it is. With reference to the arguments in this case, let me just say, I think, given the testimony in this case with reference to count 2, the failure to stop at an accident scene where there was a death involved, that being count 2, that the people have indeed sustained their burden on count 2. The testimony of the HVA responders, Miss Grady, particularly as to the vehicle going past the ambulance, at that point, then staying there approximately 30 seconds and then taking off, I think substantiates that charge. With regard to the charge of reckless driving causing death, I think certainly that there are factual issues involved as to what the defendant's vehicle was doing at the time. I think the location is important. I think that the people, as it relates to that charge, have also sustained their burden. The court, and I want to make it very clear, the notion of superseding or intervening cause and the foreseeability of whether or not this individual would be here is not limited to this individual being there. Did he come across a circumstance which should have been foreseeable for a driver on a highway? Take all of that as to a determination of foreseeability and causation. One has to remember that the ambulance is there. I had specifically asked Ms. Grady whether the lights were fully activated. The lights are fully activated. that is consistent with the statement that the defendant gave Trooper, for whatever reason, he assessed the lights, at least according to what he told the trooper, as being on the other side of the road. And then the accident happens. I'm here to make a probable cause determination as to whether or not the defendant, there's probable cause to believe that he was driving recklessly, and that in driving recklessly, that caused a death. The concept of a reckless driving is driving with a willful or wanton disregard for the safety of persons and property. I think that when you have an emergency vehicle, you're traveling. By the defendant's admission, he was doing 90, which would be 20 miles per hour over. It's even more so in terms of an excessive speed where there is an emergency responder's vehicle, because one is required to slow to a point that didn't happen. I think there is certainly enough to believe that the defendant was driving recklessly, particularly since his vehicle struck the decedent and then had enough force and momentum that he could not control that vehicle, and it continued past the ambulance that was there to ultimately try to deal with the individual on the side of the road. Maybe the argument of proximate cause, there might be a factual development that would lead that to be maybe addressed in circuit court. But from a factual standpoint, the court, in looking at all of this, believes also that will have sustained their burden and would also bind the defendant over to stand trial on the count of reckless driving causing death, or taking all of the factual circumstances into account during the course of the testimony.
Your Honor, we would wait for a reading, stand mute.
And then, having waived formal reading, standing mute, the court will enter a not guilty plea as to both counts. Pre-trial in this matter will be set
August 11th at 1:30 with Judge Cook.
August 11th, 2026, 1:30. Anything as to bond?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Bond will continue.
When appropriate, may I approach to sign the information?
Yes, sir. Mr. Bellinger, can I see you in back, please?
Yes, Your Honor.
Thank you. He needs to sign that. Those are his exhibits. Before I talk to Bellinger, are they ready?
I did not call
But
them. Ready.
are you ready, Mr. Ray?
Yes, sir.
Okay, let me do that, then I'll talk to him.
Hugo G. Mack appearing with on behalf of Mr. Anthony Johnson. Mr. Johnson, please step up a little closer. Please state your name for the record, please.
Anthony Johnson.
Thank you. What are we doing?
Your Honor, a couple weeks ago, the prosecutor asked the court for 2 weeks to attempt to contact the alleged victim in this matter. I've been in contact speaking with Mr. Cook. They have not been able to do so. The rub in this case comes in that when you allowed them 2 weeks to contact the alleged victim, my client was in jail then and remains in jail now. Now, the reason he's in jail is because of this charge, and he's on parole. The fact of him having this charge constituted a parole hold. So what happened, Judge, is that the court, because the court was going to set it for 1 week, I'm sure you remember, but Mr. Cook said, okay, I need more time. The court said, okay, Mr. Cook, 2 weeks. So they've had 2 weeks to contact this alleged victim. They have not done so. In conversation with Mr. Cook, he's saying, well, okay, well, if it's going to be a jury trial, then final settlement conferences are in August. So apparently what Mr. Cook is saying, even though the court graciously allowed them an extra week to contact the purported victim, he's comfortable with having my client stay in custody for.
I don't think that that's, and Mr. Mack, I don't think, as I'm recalling everything, that was ever Mr. Cook's position. I mean, he wanted to contact the victim. I think he understood and appreciated the entirety of it. I think we all did. Quite frankly, Mr. Cook may not have been under an obligation to do anything. And if you wanted a jury trial, then you get set when it gets set. I'm sure he was going to try to use his best efforts, but.
So, Your Honor, what I'm asking the court is that in light of the fact that my client is in custody, the court has given the prosecutor great opportunity to contact the alleged victim. So first of all, I'd be asking for a motion to dismiss.
That's going to be denied. This would be the appropriate time. And, you know, Mr. Mack, the problem here becomes, look, these kinds of things happen in DV cases. There's not a doubt that alleged victims disappear, then appear and do whatever. You know, that happens. So what are we doing on this case?
Your Honor, if the court will not entertain the motion to dismiss, I asked the court to.
It denied.
Okay, if the court's denied the motion to dismiss, Your Honor, my client informs me that I believe he's under a $20,000 cash or surety bond. My client will be exercising his right a jury trial. And in light of that fact, and the court's protocol is to only have jury trials every other month. So in other words, the next jury trial.
Not my schedule. That's set by other people. I'd have them every day if I could.
Yes, sir, I understand. So, Your Honor, so in that regard, my client is requesting, he has a job, children to support, one child with mental illness. So what my client is asking the court to do, would the court consider reducing his bond to a $10,000 bond, cash or surety, with a tether? That more than protects the interests of society in general, or the protection of the alleged victim in specific. It would allow my client, if he can convince the parole officer to lift the parole hold, which we don't know, but it would certainly give him an opportunity, Judge. And that's all he's asking for, an opportunity.
That's the other thing. Yeah, I love it when we get up here and it was half the story, because I think the other half of that story about the adjournment was contacting parole to figure out what they were going to do. I haven't heard anything about that.
Yes, he did contact. I've been in touch with parole officer myself, and the court saying depends on what's happening with this case. That will determine the whether there's going to be a parole violation charge or not. So everything is up in the air, and all I'm asking, Judge, is to please give the man a chance to maintain his employment and look after his family.
But what are they going to do with it? Because if he gets out, that's part of the problem. If I give him a bond, if I gave him a PR, I'm not saying that I would, but if I give him a PR, but they didn't just grab him up, what have we done? Oh, that's why they were supposed to be. Both sides were supposed to do something or try to do something. So,
and Your Honor, absolutely correct. And what my client informs me is he does have another place to stay, a stable place to stay, and we'll communicate that with the parole officer. And it's a big if the parole officer would even lift the parole hold, Judge. We don't even know that. But I'm saying you could certainly, and we're asking you to please at least give it a plausible chance of success, a chance of success. The court is well familiar with the GPS tethers, set whatever parameters the court desires. There's no danger to anybody, Judge. And the man can work and help support his family and pose no threat to anyone, Judge.
Mr. Cook.
I want to make sure the record is clear on certain things. It is absolutely correct that at the last pretrial, which to my recollection would have been, I believe, June 1st, if my notes are correct.
Yes.
At that time, I believe defense counsel asked to set the matter for final settlement conference, and the people asked instead to adjourn the matter for a pretrial to give the people an opportunity to discuss with the victim, because by that point, the case was not even, I believe, 10 days old.
Right.
And we had not had an opportunity to discuss with the victim. At that time, I don't know if I made the representation on the record or if it was just in a conversation with Mr. Mack, but my notes indicate that part of the reason for adjourning was to potentially set it for a bench trial at an earlier date than the August FSC in order to get this case heard as expeditiously as possible in the event that the people were either unaware if they could proceed or unable to proceed. Had confirmation from the victim they would not be interested in prosecution. I am still of the opinion that I want to get this case resolved as soon as possible in a way that is fair both to the defendant and the victim. And to that, I had a conversation with Mr. Mack this early afternoon, morning. I don't remember exactly when, but it was earlier today, where I told him we can set it for the earliest available bench trial date if the court and defense counsel wanted to, in order to get this matter heard before the August FSC. Because contrary to what Mr. Mack stated, I do not enjoy seeing the defendant in custody, and I don't want him to remain in custody any longer than is just and fair. So I would not have an objection to setting this matter for a bench trial. I want this case to be resolved, but I have to take into consideration the victim's wish. We've been given that opportunity and I've not been able to contact her. We have made efforts, but the simple fact of the matter is we simply do not have good contact information for this victim. Having gotten that opportunity, I'm now trying to get this case heard and resolved as quickly as possible, which I believe would be by a bench trial, as I fully expect we'll reach a resolution on that day. But I wanted to make sure that it is clear that I am not out here trying to get Mr. Johnson to stay in custody as long as possible, that I enjoy a deprivation of his liberty. I am simply trying to make sure that the victim and the defendant both are heard and respected in these proceedings.
Am I allowed to respond or no?
Well, you can respond. I'm just going to say I agree with Mr. Cook. He's been practicing before me. He doesn't like anybody sitting in jail. And frankly, there are times where he doesn't have a problem with somebody being released, but the court does. And so, Mr. Mack, I get attorneys have to do their job and everything, but people just be fair to each other. Because he doesn't attribute you representing this defendant as that you want anybody that beats a woman to walk out there. He's not saying that. So
Can you consider $10,000?
What am I setting it for?
Well, Your Honor, it would be allowing to be scheduled for a final settlement conference August.
Jury final settlement conference will be set for
August 7th.
August 7th, 2026, 9 a.m. Jury selection if necessary. August 10th, 2026 at 8:30. Both of those proceedings are in person. What I'm going to do reference the defendant's bond is I'm going to continue the defendant's bond as it is. If the defense counsel through the parole officer indicates that the defendant would not be taken into custody, basically would lift the hold at this point. The court would consider reducing bond.
All right, Your Honor.
Thank you. Are you almost ready?
To be ready for the mechanisms by that, Your Honor. Stand if you need a break, then you move on.
I do. All right, court's gonna stand in brief.
What started as a simple plea hearing quickly turned into a reality check the defendant won't forget. A young man appeared in court after being accused of damaging another person's vehicle. According to the case, he had struck and broken the victim's windows, leaving behind property that could have resulted in much more serious consequences. Through negotiations, prosecutors agreed to reduce the matter to a civil infraction. The defendant also paid restitution to the victim, and both sides reached an agreement before the hearing. But Judge McNally wasn't impressed. After reviewing the file, he looked directly at the defendant and made it clear just how fortunate he was. The judge told him that he should go buy a lottery ticket because he had received an opportunity many defendants never get. While the lawyers had worked out a deal, the judge wanted him to understand that breaking someone's windows and damaging property is serious behavior. Then came the warning. You better walk out of here and realize how lucky you got. The courtroom fell silent. Instead of facing a much harsher outcome, the defendant received a reduced penalty, a fine, and a chance to move forward without further trouble. But the judge promised one thing. If he ever saw him back in court again, he would remember him. For the defendant, the message was clear. Second chances don't come often, and wasting one could be the biggest mistake of all.